Hey everyone, this is Rob Ryder. It's Wednesday, May 13th, 2015. Today, a little bit about a house divided cannot stand. We know that from the Bible. And Jesus was talking about the devil's house. And then while supplies last, your business with the IRS. My email address, again, I'm Rob Ryder. Email address is court of record, COURTOFRECORD at AOL.com. If you can, please donate. The coffers are very low again. I want to thank the few, but the ones that did, again, helped me get over the edge last time, and praise God, that's the way it usually works out. So if you could possibly, and haven't, or have, and still can, well, please do. And PayPal is an easy way to do it. It goes to my daughter's PayPal account, which is ashleyritluski@gmail.com. Or you could mail it to me, to Robert Ritluski. Yes, that's more like me. Rob Ryder's just a name I made up. Go figure. It's an avatar. 10955 14 Mile Road, Rockford, Michigan 49341. Let's get right into this. So, Title 2 of the United States Code, 2 U.S.C. 25, says, Oath of Speaker, Members, and Delegates. At the first session of Congress after every general election of representatives, the oath of office shall be administered by any member of the House of Representatives to the Speaker, and the Speaker to all the members and the delegates present. I should highlight that. And by the Speaker to the members and delegates present. And to the clerk, previous to entering on any other business, and to the members and delegates who afterwards appear previous to their taking their seats. So until this part's done, obviously they can't do any work. Makes pretty good sense to me. Let's continue on. The clerk of the House of Representatives on the 80th and each succeeding, so 80th, 80, Congress, shall cause the oath of office to be printed, furnishing 2 copies to each member and delegate who has taken an oath of office in accordance with the law, which shall be subscribed in person by the member or delegate, who shall thereupon deliver them to the clerk, one to be filed in the records of the House of Representatives, and the other to be recorded in the Journal of the House and in the Congressional Record. So there's two books, the Journal of the House and Congressional Record. Journal of the House is for the House, and the Congressional Record is for the Senate. But we're only talking about people that looks like that are members of the House, so they put it in both books anyways, and they give another copy to the clerk. Well, by God, try to get a copy of their oath. You might find it's a little bit difficult. However, and such signed copies or certified copies thereof, or of either of such records thereof, so the Journal or the Congressional Record, shall be admissible in evidence in any court of the United States, and shall be conclusive proof of the fact that the signer duly took the oath of office in accordance with the law. Well, what's the opposite of that? If he doesn't have it, then there is no proof that they took the office, and therefore they can't do any business in the Congress. And basically we just have a usurper of government power occupying a chair that he is in a government that he's a traitor of. So we may have to do something about that. We should go see if they actually have an oath. And so we've asked a couple, 3, 4 of us that actually do this stuff. Instead of just thinking about doing, we go do. The best time to do this stuff is when you don't have a problem, right? Don't wait till you're in court. You should be trying things now because you can. And so we asked for copies of the oath, and we've yet to see them. Then codification, the last paragraph of this section was which permitted members and delegates of the House of Representatives of the 80th Congress to subscribe and deliver 2 copies of the oath of office at any time before the expiration of the 80th Congress was admitted. Well, I wonder what happened in the 80th Congress that these guys, they didn't put their oath in until the end, even if they put one in, until the end of the Congress. That's the way they used to do it. Now they have to put it in before and shall thereupon deliver to the clerk, one to be filed at blah blah blah, and each signed copy certified thereof shall be admissible in court. proof. Where did it say? Oh, previous to their taking their seats. So the question is, does this mean when are they supposed to file this piece of paper? Because this is all talking about at the first session of the Congress. Okay. So that's about it on that. Now, how would you find out what this is? Well, you would go and look at a copy of the Journal of the House of Representatives. And so if you just Google Journal of the House, it'll take you, one of the hits will be to the GPO, the Government Printing Office, and we might go there ourselves here in just a second. And you can find these. So this is 2011, because they only had it up to 2012, and that's the even number years, the year they get elected in November, but they actually take the seat in the odd number year, which in this case is 2011. And began and held at the Capitol in the city of Washington in the District of Columbia on Wednesday, the 5th day of January, in the year of our Lord, 2011, being the first session. It didn't say the regular session, the first session, of the 112th Congress, held under the Constitution of the United States, and in the 235th year of the independence of the United States. Okay. That's all wonderful. What do we need to know this for? Well, if you, in this case, you got to go down to the fourth page, where it talks about oath of office speaker. At the request of the speaker-elect, the oath of office was then administered to him by Mr. Dingell, Dean of the House. Oath of office members-elect. Delegate-elect, resident commissioner-elect. The Speaker said, according to precedent, the chair will swear in the House-elect, or swear in the members-elect of the House en masse. The members-elect will rise. The chair will now administer the oath of office. The members-elect, delegates-elect, residents-elect then rose in their places and took the oath of office prescribed by law. Well, back in here, it said the Speaker was going to give the oath, and the chair gave the oath. Who's the chair, first of all? To me, it's like talking to the mop. Right? You're just talking to an empty chair. So they swore in mass. That's the point, right? So they did swear in mass. So this says. But if you were to keep going through, and so, because you may want to do this on your own to see for yourself, because you can download this as a PDF, this journal, right? You can do a word search, go under edit, put in find, and just put in the word oath and start clicking through and see where you see the word oath. And you don't see it very often in this. This is like a 1,400 page book. I just grabbed the first 4 pages because, again, that's where it talks about them taking their oath. And it doesn't say anything about them subscribing their oath, right? They're not named, so we don't know who actually did. So the question is, right, because this does have, they did a roll by last name, and then they all stood and they took this oath, but this oath was done by precedence, not by law, but by precedent, from the chair, and it's supposed to be the Speaker. It doesn't talk about them subscribing their oath or anything, and that is what this talked about. The clerk of the House of Representatives, the 80th and each succeeding Congress, shall cause the oath of office to be printed, furnishing 2 copies to each member and delegate who has taken the oath of office in accordance with the law, and which shall be subscribed in person by the member or delegate, who shall thereupon deliver to the clerk one to be filed in the records of the House of Representatives, and the other recorded in the journal and in the congressional record. So we should be able to ask the clerk for a copy of the record, We'll try that next. But asking your representative hasn't led to anything. What else was there on that? Now they did do, since we have this, and we can, somebody did do an oath. If you get enough of these pages and you go through and you look, at a certain time people come in, like here's Karen Haas of the state of Maryland to be hereby chosen clerk of the House of Representatives. Right? She may take an oath, but that's as an officer of the House, not a member. But there is no indication that each member has taken an oath. And on the Senate side, they do it where they show in groups of 4 being called forward to come and take an oath and subscribe the book and blah, 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 blah. And they don't do that here in the House. So I don't believe that the House has been properly elected, and that would divide the House. And well, I don't have much more to say on it this time. It's just something I came across, and I thought it important enough to stop and do a video on, because you know, this is the kind of stuff where, well, if they're not actually elected, yet they're sitting there, then technically they're usurping the office, and that makes them a traitor to the Constitution. And I should be able to get a hold of the Sergeant at Arms of the House of Representatives and let him know, which I plan on doing. My God, he's got an email address. Look at that. By the same token, I should be able to tell the Capitol Police. They're a federal law enforcement agency, and they're going to enforce a federal law. These guys didn't subscribe their oath. Therefore, they're not in the office. Kick them out until they do. I'm not saying they can't do it, but if they haven't done it, then they're not in office. And anything they've done, without it being done, you know, has no force and effect. So, just one last thing on this, because, you know, it's always, you read it and read it and read it, and you wonder what you're reading some days, but in Revised Statute Section 30, derived from the Act of 1789, for God's sakes, way back. What act was June 1st, 1789, which is now 1 Stat 23. The last paragraph of this section, which permitted members and delegates of the House of Representatives, 80th Congress, to subscribe and deliver 2 signed copies of the printed oath of office at any time before the expiration of the 80th Congress, was admitted. Does that mean it's no longer in effect? Amendments, 1948. Some act of 18. Now, that's a funny thing. They don't put the names of the acts, they just put the dates. Makes it a little bit harder to find. Added last 2 paragraphs to provide a way by which any member of the House of Representatives can establish by record evidence the fact that the members took the oath of office and so became a member. And they don't have any evidence so far. They haven't produced any. Right? They're supposed to subscribe it in person, deliver it to the clerk, one to be put in a copy of the records of the House of Representatives. Whatever that is, what are the records of the House of Representatives? We should be able to find it in there. Should have been recorded in the journal. It isn't. And it should be recorded in the congressional record. And it isn't. Okay. Hang on just 1 second here so I can go grab something. Hang on. Okay, just real quick, a few more things on this journal. So if you go to Google, Journal of the House, you'll find something for the GPO about Journal of the House Representatives. Click on that, blah, 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 and all that blah, blah is actually this right here. And you can go read all of it if you want to, but it says about the Journal of the House Representatives. In Article 1, Section 5 of the United States Constitution, it states, each House shall keep a journal of its proceedings and from time to time publish the same. excepting as such parts as may in their judgment require secrecy. Accordingly, the journal, and not the congressional record, is the official record of the proceedings of the House. The journal is the official record of proceedings of each legislative day in the House of Representatives. Well, that is the official record. And there's nothing in there that says these guys subscribed their oath. It says a bunch of them stood up and it was given en masse, but who said, doesn't mean anybody stood and actually said it. Specifically, we don't know who these people are. They didn't subscribe the oath. And, and that's about all I got to say on that, apparently. What else was there, though? But because we're here, right, so right here, Journal of the House of Representatives, if you click on it and you wait a second, it takes you to this blah, blah, blah. And here is Journal of the House of Representatives. And it only goes, as you can see, to 2012. But because they're elected in the even number year, they actually would be taking the oath in the first session of the odd number year, and we were looking at this one for 2011. So that's interesting. Some other interesting things about things you can find on the GPO site. This is catalog.gpo.gov. This is for finding a slip law, or where you might be able to get a copy, because I'm going to talk about that just a little bit here. But if you remember from the last video, 1 U.S.C. 113 says copies of slip laws issued under the authority of the archivist are competent evidence in all courts, yada, yada, yada. I'll go find the exact thing here in a second, but because I'm here. So here you can find them, right? So this is the catalog page, and if you were to put in the one I was looking for at the time, because I had the name, was False Statements Accountability Act, which I'd already put in before, so I put it in. Hit go. Right, it takes you to this page, and you could have lots of hits depending on how well you did your tying it together. But if we click on this, it takes you to a page that looks like this, full view of record. All right, so it gives the document number, item number, so forth and so on. But locate in the library, paper, right? Because you can be looking at a certified copy online, but if you want to have it issued under the authority of the archivist in paper form, right, it should have a seal or something on it. So if you go here and click on that, now you got different ways to look for a federal depository library, and you can pick your state, Michigan. Right? You can pick as many states. You can, yada, 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 search. Okay. Locate federal depository libraries by city, state. All right. So if they're listed on here, well, then they're a depository library. And it's part of this federal system of depository libraries, and because they are, you should be able to go there to all of them because they're supposed to make this information available to you for free. And as it turns out, the first one I tried was, where are them boys? Grand Valley State College, Law College. A lot of these, as you can see, are law colleges. College of Law. This one I tried. The Selected Depository Library. So they may get off the hook because, I don't know. See, these are selective, 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 selective. However, on the previous page, right, when I was doing this, it said, well, these are, you find the ones that have a paper copy, and by God, if they're on here, they should have a paper copy. But Roe in Illinois and Bobby in Arizona had both done this, and they were able to get copies sent to them by their libraries of a particular act. Like this act is like a 2 or 3 page act. And it's the False Statements Act that says if they omit to tell you something, that's a false statement. If the paperwork is incorrect and they won't fix it, well, that's a false statement. And if they lie to you, it's a false statement. And they're all federal crimes. And if you have that law under seal, it's valid in all courts, proceedings, so forth and so on. We'll go look at that again in just a second. But just, I wanted to show you how to find this stuff. That's all I'm really doing, right? So this is that page, right? Locate in the library, paper. Clicked on it. It took me to the page where allow me to choose a state or whatever, and it says I can go to these particular libraries to get it. Okay. And I don't know if there's anything else in that I needed to show you. No, except that it's called, try and go back to the beginning, right here. Catalog United States Government Publications. Okay, so I need to go find one more thing again. I may be doing this quite often. And because some things just can't be said enough, I'll talk about this again. 1 U.S.C. 113. It says, the additional laws and treaties of the United States published by Little and Brown, some publishing company, and the publications in slip or pamphlet form of laws of the United States issued under the authority of the Archivist of the United States, and the treaties and blah, 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 shall be competent evidence of the several public and private acts of Congress and the treaties, international agreements, blah, 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 proclamations, in all courts of law and equity and of maritime jurisdiction, and in all tribunals and public offices of the United States and of the several states, without any further proof of authentication necessary. Get your law under seal and go take it in. You're supposed to be able to use this in public offices. So if you're trying to get something recorded and they won't follow the law, then bring in the law under seal and say, well, this law says you're supposed to do it this way. Because apparently you can get both federal law and it looks like state law from the same people. So let's look at an example, if I can find it real quick, where we put that. Laws from library. All right, this is what it looked like for Roe. Got a couple of them. So this was, she asked for Public Law 104-237. Well, actually, she asked for the, let's see what it calls it here, the False Statements Act. Right. This act may be cited as False Statements Accountability Act of 1996. Okay, so she asked him for that. And they sent her this PDF that has the seal of the Illinois State Library on it. And it has a card catalog number, like that's a public record number, right? That would tell you specifically what you're looking at and where it came from. But she didn't have it certified. And I think that that's what's missing, is that we have to have this certified yet. And they can do it. They can certify the law. All they're going to say is it came out of their library. But what library are we talking about? It's the law library. It's the library full of laws. You want to use a law, go get a copy and check it out. Just like using a book. And take it and put it in your court case. And so Bob in Arizona did about the same thing, right? Because we wanted to ask for the same law to see what it looked like. And in his case, it has this kind of sticker on it for the Arizona State Library, but it didn't have any kind of barcode on it. But they did say that, so Bob said, well, can I get a certified copy of this law? They said, yes, you can come down, and for $3, basically they put a little certificate on it that says they're saying it came from their system, and they get it notarized. And it sounded like he could do that by mailing them a money order for $3. So that's where we're at now. It's been mailed. We're waiting to see what comes back. But right, so places that were listed as having this law, and of course state library should have the law, you would think. State law library, duh. Well, yeah. Where's that at? It's the library of the laws. Go get a copy, get the seal on it, and say, well, this is what the law is in the law library. They always tell you to go to the law library to get information. They don't tell you to, go get it under seal, bring it back, put it in your court case, and give it to the exhibit clerk, because they have an exhibit clerk also, not just the place you keep putting paperwork in the window. The exhibit clerk. Got to ask for the exhibit clerk and give him your exhibit. And your exhibit's going to be a law under the seal, and it just became, according to this, in all courts of law, equity, and of maritime jurisdiction, and in all tribunals and public offices of the United States and of the several states, without any further proof of authentication thereof. It is the law. And then 114, sealing of instruments. In all cases where a seal is necessary by law to any commission, process, or other instrument, like a slip law, provided for by the laws of Congress, it shall be lawful to affix the proper seal by making an impression therein directly on the paper to which such seal is necessary, which shall be valid as if made on wax or other adhesive substance. So if they seal your frickin' document, it's sealed. And so all we really need to know, what does this mean here? Publication, slip pamphlet form of the laws of the United States, issued under the authority of the Archivist of the United States. What does that mean? Issued under the authority of the Archivist of the United States. We need a better interpretation of law. So I've asked that question to the Archivist, and it's been a couple days yet, and I haven't heard anything. That's not unusual for me. I don't usually hear from some of these people. But what are you going to do, right? Ask a question and see what they say. Now, continuing on, and I suggest everybody go look at one U.S.C. just to see what's in it, but because this has more to do with the publication of laws. The Code of Laws of the United States and Supplements, and the District of Columbia Code and Supplements. Director of the Government Publishing Office shall print such numbers as are necessary for depository, library, distribution, and sale. Right? Slip laws. That's what we're talking about. All that stuff needs to be published. There shall be prepared and published under the supervision of the Committee of the Judiciary of the House of Representatives. Now, this is one of those other things. If you just go Google Committee of the Judiciary of the House of Representatives, it's going to take you to the Judiciary Committee of the House of Representatives, but that isn't what it was called. This is the Committee of the Judiciary of the House of Representatives. Again, it's one of these shadow offices that this is what they called it. Where is it? And this is not what you will find by doing a simple search. Now, if you put it in quotes and put it in, you'll see it referenced in places, but it never, at least so far, I mean, I haven't looked that long or that hard, but I haven't found out who they're talking about. So for you really deep researchers, who is the Committee of the Judiciary of the House of Representatives? Committee of the Judiciary of the House of Representatives. It's not a mistake. It's a particular place, but it's like the difference between the United States District Court for the Western District of Michigan and the United States District Court, Western District of Michigan. Not having the for the changes it completely. The for the is the Article 3 court. If it doesn't have for the in it, I don't know what it is, but it's not the Article 3 court. So it's not a court that can make a final determination in your private rights, because that can only be done by an Article 3 court. And your private rights are the right to life, liberty, pursuit of happiness, private property, things like that. We don't have any constitutional rights. You have private rights. They're called civil liberties. And as it turns out, Homeland Security, you can file a complaint for civil liberties. So I did. Look at that in just a bit. Codes and supplements as evidence of laws of the United States, District of Columbia, and on and on and on. So what this says, though, is in the United States Code, the matter set forth in the edition of the code, right? So this is like 1, 2, 3, 4, 5, 6 United States codes, all the way up to 50. It says that if it's in the code, it establishes prima facie the laws of the United States. But that's a rebuttable presumption, right? Because it goes on to say, provided, however, that whenever titles of the code shall have been enacted into positive law, the text thereof shall be legal evidence of the laws therein contained in all courts of the United States, several states, territories, insular possessions of the United States. Which is saying that if it's a positive law title, like Title I is, and I think Title V is, and there's quite a few of them. I talked about in my last video. You should just be able to put the text in and nothing else, because it's positive law. But I was talking earlier about the stuff in 2 U.S.C. 25. Well, Title II is the Congress, and it's not positive law. So if I wanted to use that law, 25, I would have to go and find the slip law, or the act, in other words, that enacted the law, and use it in place of what they put into the title. Because in the non-positive law titles, they're just editorial additions, someplace to put the law that has, because it has something to do with that topic. But whoever decides when they're codified properly, they haven't done all the titles yet. They've done like half of them, it looks like. And right, so if it's not a positive law title and you quote it, it's just prima facie evidence. And somebody can say, well, that isn't what the law says, and they'd be correct, because that's what they do. They change a few words or something between what's in the editorial version of a non-positive law title and what the slip law says. And this is good too, the District of Columbia Code. The code of the District of Columbia may be cited as the D.C. code. And you're not going to find something called the Code of District of Columbia all by itself. You may find Code of District Columbia, or the official Code of District Columbia, or the Code of District of Columbia unofficial, or whatever, but not Code of District of Columbia. And I don't know if it has to have the on it or not by itself. And especially not D.C. code. They're talking about something happened back in the 1900s, like 1908 or something like that, and I haven't had a chance to track it down yet, right? But the reason it's kind of important is that's like that's the state law of the District of Columbia, and since it doesn't look like the states were ever properly formed, then we're all still in the territory, and our state is D.C., it's the state capital, and so that's the state law, the law of the state of the nation. Possibly. Now here's the positive law titles, right? There's a whole bunch of them. So all of these, now this says 18, but by God, I don't know that if it says 18, I guess it is 18. I'm not going to argue with it anymore. It says it in here. It's 18. Title 18 is positive law. So whatever you quote in the text should be considered positive law. But I still think you need to get a seal on it, so that you can say this is the text that came out of this law, and so says the librarian, because that's where I went to get it from. It has to be, somehow you got to certify that the copy came from the law library. It just seems to me like that makes sense, number one. And number two, it would be something that they would do, so that it would make everything you put in not have any value until you did this. All right. One more second. Hang on. Okay. I'm going to talk about some IRS stuff, some stuff I think you're really going to like. And this is more like a public service announcement, this part. There's this section, rev.proc.2012-1. And I think they do this every year, so it could be that it gets new every year. But it talks about the letter rulings, information letters, and termination letters that the IRS issues to certain individuals. And any government agency, anybody that has a taxpayer ID number that claims to be tax exempt for whatever reason has to have a letter ruling from the IRS that they agree they are, or it's rebuttable that they are. So, for instance, a letter ruling. A letter ruling is a written determination issued to a taxpayer by an associate office in response to the taxpayer's written inquiry, filed prior to the filing of returns or reports that are required by the tax laws about the status of the tax for tax purposes or tax effects of its acts or transactions. A letter ruling interprets the tax law and applies them to the taxpayer's specific set of facts. A letter ruling is issued when appropriate in the interest of sound tax administration. One type of letter ruling is an associate office response granting or denying a request for a change in the taxpayer's method of accounting or accounting period. Once issued, a letter ruling may be revoked or modified for a number of reasons. A letter ruling may be issued with a closing agreement. However, a closing agreement is final unless fraud, malfeasance, or misrepresentation material fact can be shown. And that's what the closing agreement is, and I'm not going to spend a lot of time on this, but we may end up using these ourselves to get a final determination because of what we're going to look at. And Roe came across this, and it's like, whoa, what the hell is this stuff? But very interesting. Entity classification election. Pay attention. Now we're going to something different completely. This is just IRS stuff. For the United States income tax purposes, a business entity may elect to be treated as either a corporation or as other than a corporation. Either as or not. This entity classification election is made by filing the Internal Revenue Service Form 8832, which looks like this. Right, and actually the form is, just a couple pages long. I'm on page 4. I'm already in the instructions, so it was 3 pages long. And as you can see, it's mainly blank places with a few check boxes. My kind of form. We'll get back to the form in a minute. Absent filing the form. If you don't file 8832, absent filing the form, a default classification applies. You don't file, they're going to classify something for you. U.S. corporations of the type that can be publicly traded must be treated as corporations. So if a corporation doesn't file in 8832, then they're going to be treated as a corporation if they're publicly traded. If they're of that type, right? Because there's different types of corporations. They will certainly be treated as a corporation whether they put it in or not. There is a list of specific foreign entities that must be treated as corporations. Okay, so there's places to find out. But if an entity is not classified as a corporation, it is treated as a partnership for U.S. tax purposes if it has more than one owner or is a disregarded entity if it has a single owner. In other words, it's treated as part of the single owner. The disregarded entity. Did you know your all capital letter name is a disregarded entity because it has one owner, you, and you haven't elected to have it treated as a corporation. Therefore, it's going to be treated as a disregarded entity just like it's you. So that just made you responsible for all the debts of the personally liable for anything that happens to the uppercase name. Apparently. This classification is either U.S. or non-U.S. entity, blah, blah, blah. Eligibility to make an election. An entity which is eligible to make an election is referred to as an eligible entity. However, the following types of business entities are treated as eligible entities. An eligible entity that previously elected to be an association taxable as a corporation by filing 8832. The entity that elects to be classified as a corporation by filing 8832 can make another election to change its classification subject to the 60-month limitation rule. Well, whatever that means. A foreign eligible entity becomes an associate taxable as a corporation under foreign default rules. Okay, so, is there any way that one of these could be us? Our all capital letter name. because your all capital letter name was created when you were a child and you were given a guardian ad litem, and they could easily have done it as an association and put the paperwork in and said, yeah, treat them as, or never put the paperwork in. So it was originally created as an association. Or they put it in and said, treat it as a disregarded entity. But you can change it. Default classification. An eligible entity is classified for tax purposes under default rules described below unless it files the Form 8832 or the 2553, election for small business corporation. And I wonder if that's when you were a child, that kind of small business. Because you can change that one. You can change from being a small business at some point to a larger business. To elect classification, so forth and so on. The IRS uses information entered on the form to establish entities' filing and reporting requirements for federal tax purposes. Certain domestic and foreign entities that were in existence before January 1st have established federal tax classification. Generally, do not need to make election to continue that classification. But if you want to change it, then you do. Unless an election is made on Form 8832, a domestic entity will be classified by default as a partnership if it has 2 or more members, or a disregarded as an entity separate from its owner if it has a single owner. A change in the number of members of an eligible entity classified as an association does not affect the entity's classification. Again, that was a small business association. A change in the number of members of an eligible entity classified as an association, defined below, does not affect the entity's classification. But the main one is disregarded as an entity separate from its owner. They won't consider it separate from the owner, is all that's saying. Right? That's default. It's not separated from its owner. So it's like you just became a sole proprietorship. And instead of being a sole proprietorship, which is one, we should be a corporate sole, which is what a bishop is, where you're separated. Now you have a separation between you and your public persona, your all capital letter name. Unless an election is made, but you are the owner. Because the paperwork will show you're the owner. You're claiming ownership of the name. You're just separating it from your proper person by claiming it to be a corporation. Unless an election is made on 8832, a foreign eligible entity will be classified a default partnership if it has 2 or more members, and at least one does not have limited liability, an association, corporation. If all members have limited liability, blah, 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 blah. By default, as a partnership or disregarded entity if it has one owner. So let's think about this. When you get married, that's a civil union of your 2 estates. Right? So a partnership happened. We'll look at that a little bit deeper on something else. But your single entity still exists. Right? You didn't change who you are. You just merged your estates together. And so if you're married, I think you need to do something. And I think you need to do for that entity. And you need to do something for your separate entity. If an entity has been operating under one classification for some time, but then elects to change its classification, there may be tax consequences. The initial regulations were unclear on this point, so the IRS issued some rules to do something about it. Use of international tax planning, which take advantage of differences in classification of entity as a corporation or not in multiple jurisdictions in order to engage in cross-border tax arbitrage. Whatever that is. Yeah. It goes on and on and on and on and on. Classification of certain business entities. Thus, elections are necessary only when the eligible entity chooses to be classified initially as other than default. So other than not being separated. We want to be separated, so we got to fill out the form. And we'll just take a look at the form, right? Then we'll look at a few more details about it. So what do they want? Name of the eligible entity. I say that's your all caps. Employer identification. I say that's your Social Security. number, street, room, blah, blah. Yep. City, town, city, town, city, town. Yep. I'm going to say it's not a newly formed entity. It's been, mine was, I got paperwork shows it was created way back in 1958. So I'm going to check B, go to 2A. Has the eligible entity previously filed an entity election that had an effective date within the last 60 months? Nope. Go to 3. Does the entity have more than one owner? Nope. Go to 4. If the eligible entity has only one owner, provide the following information. Name of owner. Now you put your proper case name. Identifying number of the owner. Well, the Social Security number. You share that number with your legal person. But let's say that this was the partnership, right? Then I think here, because you're one of the parent corporations, so if you're the husband or the wife, you would fill this out here on this line. Okay, domestic entity electing to be classified as an association, taxable as a corporation. A domestic entity electing to be classified as a partnership. Domestic eligible entity with a single owner electing to be disregarded as a separate entity. No, I'd say I'm going to click A. I want to be a domestic eligible entity electing to be classified as an association, taxable as a corporation. Yeah, corporations don't pay taxes. If the eligible entity is created or organized in a foreign jurisdiction, provide the foreign country or organization. Well, I don't believe so. I'm from the United States of America. That's one of the things I'm complaining about is they haven't done your records properly, and so you don't have your status as a national of the United States. Number 8, election is to be effective whenever. Number 9, the title of contact person who the IRS may call for more information. Well, that would be me. So now we could go do all this and wonder if we're doing it right? Or we could call them and ask them some questions, which is kind of what I'm thinking of doing. But because you can get late election relief, right? Like, well, that sounds to me like, well, I'm just doing it now, but maybe I should have done it a long time ago, and I didn't. But I can now. I just need to explain why. So I got a little more research to do, and I'm hoping people much smarter than me in the IRS will take a look at this. But it's Form 8832, and it has to do with entity classification election and a guy called the disregarded entity. Right? A disregarded entity is a business entity that is separate from its owner, but which elects to be disregarded as separate from its owner, so to be the same as the owner for federal tax purposes. It just made you responsible for its taxes. And your business is making money all the time. You're just not getting any credit for it, and so they're going to make you, but they're going to make you responsible for them. Because you didn't separate it. If a disregarded entity is owned by an individual, it is treated as a sole proprietor. Right? So if it's allowed to, if you didn't put the form in, it is a disregarded entity, and therefore it's treated as a sole proprietor. An eligible entity with a single owner can elect to be classified as an association or to be disregarded as an entity separate from its owner. It can be an association, a corporation basically, or a sole proprietorship. The only business type that fits this qualification is a disregarded entity is the single member LLC, limited liability company or corporation. Right? You can read more, but single business LLC is the only disregarded entity. Sole proprietorship is not a disregarded entity because the business is not separate from the owner. And so it isn't a sole proprietorship. It's an association. It's a single member LLC. The IRS says all single member LLCs that does not elect to be a corporation will be classified by the existing federal guidance as a disregarded entity, which is taxed as a sole proprietor for income tax purposes. So basically, any or SM was, single member LLC is not taxed as a corporation, is a disregarded entity. Blah, 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 back and forth, to and fro. A sole proprietorship is not a disregarded entity because the company is not separate from its owner. Right? They're going all back and forth and to and fro, but your all caps isn't a sole, you're not a sole proprietor, your all caps. It was set up as an association because it happened when you were a baby and you had no control over it, but they made you the single member of a limited liability corporation. It's my opinion. I'm going to put the paper in and see what they do after I talk to the IRS. On and on and on, da-da-da-da-da. So, 8832 is how you're going to tie your proper person name, upper lowercase, with your all caps business name via the identification number that's the same for both of you, and tell them that you're an association now. Regardless of what you were before, you're going to change your classification. You can elect to be classified as a partnership or an association, taxable as a corporation. And you can do it once every 5 years. Well, I don't know why you'd want to change again, right? But you've never changed. So for that, because we haven't ever changed, and apparently maybe we should have, there is some late election relief, and we need to get some poop on this. And if somebody has more time and understands it better and gets that information, please send it and share it so we can all enjoy it. That'd be wonderful. Okay. Now. What else was there? In here, partnerships. Classification of certain business entities. 26 CFR 3001.7701-3. In that area, there's a number of things that have to do with classification of certain business entities. This one has to do with partnerships. So the Treasury Department and the Internal Revenue Service have become aware that taxpayers are unsure of the classification of an entity that is owned solely by a husband and wife as community property under the laws of the state. Well, what would that be? Go look at your marriage license. Whatever that name is the name of the entity. To alleviate this uncertainty, administrative simplicity, this revenue procedure provides the Internal Revenue Service with respect to taxpayers' treatment of these entities as either disregarded entities or a partnership. So if you don't claim it to be a partnership, then it's going to be considered a disregarded entity. No different than its owner, and ties the owner back into the taxes that it shouldn't have to pay. This revenue procedure provides guidance on the classification of federal tax purposes of a qualified entity, described in Section 3.02 of this revenue procedure. Right, so we should get the whole procedure, maybe. 26 CFR is the procedure, I would think. Because that's what the Code of Federal Regulations is. The U.S. Code is the law on what needs to be done, like the Acts of Congress, and the Code of Federal Regulations are the rules that are going to be followed to fulfill the law. And so when you're talking about an executive branch office, they're supposed to follow the CFR, Code of Federal Regulations. That's their rules. Right, so it would seem if you had a complaint against them, you should go to the CFR, find the rule they're not following, and send it to their ombudsman or commissioner or whoever it is. But back to this. So this section defines the term business entity as an entity recognized for federal tax purposes, include an entity with a single owner that may be disregarded as an entity separate from its owner, so being the same, that is not properly classified as a trust or otherwise subject to special treatment under the code. So if you're not a trust, you're a business entity for federal tax purposes. And I don't believe that your all caps is a trust because you don't have a signed contract with anybody. Go show me your contract. A trust is a grantor or trustor and a trustee getting together, signing a contract. Both parties would sign. They'd each have a copy that the grantee is giving the trustee the power, legal power over his property for the benefit of a beneficiary. But if he doesn't do it, the grantee can say, well, that isn't what I told you. Here's our freaking contract, and you're not following the contract. So there is no contract. Show me a written contract. If a qualified entity, as described in some section, and the husband and wife are, as community property owners, treat the entity as a disregarded entity for tax purposes, the Internal Revenue Service will accept the position that the entity is disregarded entity for federal tax purposes. So if you didn't tell them it's a partnership, they're going to say it's a disregarded entity. Right? They're forcing you to do something, and your lack of doing it will have an adverse effect on your property. If a qualified entity and the husband and wife, as community owners, treat the entity as a partnership for federal tax purposes and file the appropriate partnership returns, the Internal Revenue Service will accept the position that the entity is a partnership for federal tax purposes. All right, so if you put in paperwork that says the union of your two estates is a partnership, then the IRS will treat it that way, and there you go. So I just find that very interesting that, this is like claiming the name. This is just a different form of claiming the name. And did I close that form? Apparently I did. Yeah, just one last second. I think I can do partnerships on this one. Yeah, okay, it was right here. If an eligible entity is owned by one or more affiliated corporations that file a consolidated return, provide the name and employer identification number of the parent corporation. This is why I got to get some help from the IRS. I don't really understand it exactly, but I can certainly understand. Well, I'm going to say my all caps is not a disregarded entity, right? So if you're going to let me treat them as a corporation, then that's what I want them treated as. Okay, I'm going to go grab one more round of papers and call her a day. Hang on a second. Okay, don't freak out. Homeland Security website. And I guess the easiest way to do it is, you don't want to search the whole thing, put civil liberties into the search box and go to the Office of Civil Rights and Civil Liberties, and you can read all about it. But one way as to how to file a complaint, you can follow all that, and eventually you would end up with right, this is how you file a complaint. And yeah, I'm not going to read this page to you. I'm just going to show you what I did. So anyways, looking at this, and then this is the complaint form that you end up with, and it's fairly simple to do. Seems like it is. So what would I complain to DHS about? Well, I had asked my congressman why a couple things, although I know my congressman is my congressman, but nevertheless the district office, and pointed out that my Social Security card on the stub that you get, as part of the Social Security card, it's not the part you carry, you're supposed to put it someplace safe. It says the name on there is Robert A. Rytlewski. A. Rytlewski. Robert A. Not Alan. It's not my proper person. So that bothered me. And then when you look at your passport and you read the page it's actually the first page of the book, not the inside cover. Your picture is on the inside cover. The first page of the book says, the Secretary of State of the United States of America hereby requests all whom it may concern to permit the citizen/national of the United States named herein to pass without delay or hindrance, and in case of need to give all lawful aid and protection. But the problem is there is nobody named herein. There's a place where they could put a name. There's a blank where you could put your proper case name in there, but it's not on there. And then you sign the page. So to me, between the word herein and the signature should be the name of who was herein named, and there isn't one. So I pointed those things out, and I got a response that was less than satisfactory, and basically saying that the secretary, that they had contacted the Department of State, and only a citizen of the United States could have a passport that says the United States. Well, I claim to be a national of the United States. If you go to the Immigration and Nationality Act, Section 360, it says if you're within the territorial boundaries of the United States, geographical boundaries, I don't use those words exactly, I don't think, but right, you're within the United States. Well, that is one of the definitions of the United States, is the geographical boundaries. And you claim to be a national, and somebody else claims that you're not, then you are due a court hearing. But beyond that, Homeland Security is responsible for enforcing the Immigration and Nationality Act, and if they are saying that I'm not a national, then it's their fault, Homeland Security. And who's in charge of Homeland Security? Well, that would be this guy right here, Secretary Johnson. I'm afraid you're responsible, Secretary, for me being miscategorized, because I am definitely a national of the United States of the United States. So I decided to fill the form out, and right, so it's pretty simple stuff. First, middle name, phone, blah 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 blah. So this is really where it starts, right? This part, and so this is all fillable. You can fill it out online. Man, let's roll. But what I wanted to point out is one interesting thing that I had never seen on a complaint. I'm a professional complainer. I complain to everybody I can. I've complained to the GAO here recently that Kent County, the county I am in, is using a W-9 for the county of Kent, and they're not the same person. And they don't have a letter ruling from the IRS saying that they are who they say they are. Because even anybody, if they have a EIN number, they have to have a letter ruling to determine who they are. In fact, we may need a letter ruling to determine for the 8822 form, whatever it was we were looking at a minute ago. Right? I forgot to mention that. So I may get a hold of them to find out what I need to do. But this is Homeland Security. So this is how they want you to do this. If you to submit this form by email, please save, attach, and send to this email address. Please attach or send all information that supports your complaint, such as documents, photos, so forth. Submit copies, not originals. Put your name and date of this complaint on each document. Fax to I messed that up. Shoot, I just read it. I sent some additional stuff and I didn't put the same date. I put the date that I did it, which was the next day. Anyway, submit copies, not originals. Put your name and date of this complaint on each document. Fax it to, scan, and send it to them. Right? You keep the original, and you send them a copy. Okay? So, because I like to do this as my kind of public record, I put a complaint in, then I'm putting her on the air right now. So Robert Allen Rutluski, phone, yep, 6179. Did I do that right? Yeah. Okay. Mailing address. I gave my 12-digit zip code because I don't understand what they mean by mailing address. But I know that is the delivery point, right down to the, the last 2 digits of your house number. I don't have an alien registration. Are you in detention now? Well, is the U.S.C. a detention center for nationals of the United States? If so, then I would say I am. Am I represented by attorney? I appointed Justin Amish, U.S. Representative, 3rd District of Michigan. I appointed him my attorney because I'm supposed to be his constituent. And by definition, if I'm his constituent, he's my agent and attorney. You don't need to have a license to be an attorney. You need to have a license to be a counselor at law. But I can make you my attorney by giving you power of attorney. You just became my attorney. Right? Don't let these attorneys be attorneys. Make them be counselors at law and give legal advice. I wasn't doing it for somebody else. So what happened? Describe your complaint. So, my own proper person, Robert Allen Rutluski, is not properly registered nor recorded as a national of the United States, resulting in my civil death and the confiscation of my estate, Robert Allen Rutluski, all caps, by the Social Security Administration. My remedy is in Homeland Security's jurisdiction. I appointed U.S. Representative Justin Amish, 3rd District of Michigan, as my agent and attorney on the request for service form provided by his office and mailed it and attachments included in this mailing. I received from his district office email address a message implying that the Department of State does not consider me a national of the United States in my own proper person, Robert Allen Rutluski. This reply was not on any official letterhead, nor subscribed by any individual, leaving me to doubt if my or any other presumed U.S. representative filed their oath of office in accordance with Title V, U.S.C. 2906. And instead, these individuals are merely impersonating a public officer. In other words, I didn't like his answer, so I don't believe he's actually who he says he is. I subsequently emailed both his local and D.C. office asking for a copy of said oath, which was met with silence and could be construed as false statement in a federal matter for withholding a material fact. Evidence shows that state and local officers have not sworn proper oaths of office, not filed official bonds, and do not subscribe instruments in official capacity. That this criminal activity is also infesting Congress would come as no surprise. Perhaps Homeland Security will investigate Congress' compliance to federal statutes such as 5 U.S.C. 2906, which says they got to file their frickin' oath. When did it happen? I believe my proper person name, Robert Allen Rutluski, has endured and enforced disappearance of person, the same being a crime against humanity according to the Rome Statute of the International Criminal Court, since infancy. Therefore, since the creation of Homeland Security and its mandated duties under the Immigration and Nationality Act, the defective records it inherited are adversely affecting my private rights, which I wish you to correct, and I wish you to correct the record. My private rights, which are civil liberties, were declared God-given, unalienable by Declaration of Independence, and the protection of which the Constitution was ratified. To not protect my unalienable God-given rights could be construed as an act of treason. Now that Homeland Security officers and employees have been made aware of enemies, foreign and domestic, usurping the sovereign powers of state, in the holy name of Jesus, let your conscience be your guide. Now, please inform your secretary. Where did it happen? Well, it first happened at my hospital. Right? Because you were never properly registered as a child. In Michigan, the local register is supposed to get your birth record within 5 days. My certificate of live birth says he didn't get it for 13 days. And also it says on it the records remain in the office of the county clerk. Well, then I guess it never made it to the state. Other names. So, who did I say might have it? Well, the clerk of the county of Bay and the circuit court thereof, and the office of the state registrar in Michigan. Have you contacted any other offices? Well, in fact, I did. I contacted the chief information office, because that's another thing you could do. That's supposed to be a administrative remedy if there's an error in the record. And I had done that, because there is an error in the record. But when I started to realize, well, my congressman apparently doesn't have an oath, and nobody else's does, so let me put it in as a complaint, and maybe I can get DHS to go and investigate Congress. So, is there any other information you want us to know about or consider? Well, thanks for asking. As Homeland Security is responsible for the execution of Public Law 414, the Immigration Nationality Act, I hold Homeland Security and its Secretary officially and personally responsible for the immediate correction of all records and the restoration of my private rights, civil liberties. For the record, I am a national of the United States and invoke Section 360 of the before named Act and claim that denying me my birthright is a violation of 18 U.S.C. 2382. That would be misprision of treason. As a member of the world's oldest cultural institution, I am protected by a treaty named International Pact for Protection of Artistic and Scientific Institutions, Historical Monuments, Missions, and Collections, Heroic Pact. I am providing you a copy of my certificate of baptism documenting competent evidence to my proper person's membership. Because that act protects not only the members, or not only the institutions, but its members. By its grants and programs, Homeland Security participates with entities that have usurped the sovereign powers of state and warring with the Constitution. As an example, I include this link. Goes to Kent County, shows all the things that Homeland Security has to do with the Sheriff's Department. Kent County cannot be the government because Kent County does not have an internal revenue letter ruling for that revision, that thing we looked at, confirming a status. And when asked for a W-9, request for taxpayer identification number and certification, from its Office of County Commissioners, said office provided a W-9 for EIN number 38-6004862 under the name of Kent, or County of Kent. In other words, some organization calling itself Kent County has usurped the sovereign power of state from the political subdivision known as the County of Kent. Officers of Kent County have not sworn and filed a proper oath of office, nor have they filed an official bond, and are not elected in accordance with Michigan's election code. Submit independent audits of public funds written by unlicensed accountants in violation of law. Complaint filed with the GAO. Please stop enabling them. And so then it was just all the things I had done before. This is what I had sent to the request for service. I sent to the congressman. You know, blah, 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 all the piece parts and so forth. I guess we don't need to look at those again. But you look at this. I don't know if you can read this down here. Record having a seal. Do certify that the following is a true copy of the above record now remaining in my office. Well, it's supposed to be with the frickin' state. And it isn't. And this right here is this is the creation of all caps. There he is, all caps. But that record also is remaining in the office of the county clerk. I, Stephen Toth, clerk of the county of Bay and the circuit court thereof, the same being a court of record, having seal, do hereby certify that the following is a copy of a record of birth of, all caps, now remaining in my office. Why are they in his office? So, anyways, this is what they want you to do, right? Sign it and put your name on it. And right here, above the cancel, there's a space, and I believe that's where your proper case name should be, somewhere above your signature. So you could be herein named. And this thing to the right is the stub that you can't read it here, but it says named on the other side, and the name on the other side is Robert A. Rutluski. That's the owner of the Social Security account. But hey, here I am. There's my proper person, right? So when I was born, my proper person wasn't properly registered. Didn't get to the state registrar in time. When I was reborn, which is what the certificate of baptism shows, well, they didn't do this either properly, as it turns out, because it isn't in the diocesan records. See, I'm a Roman Catholic. My records should be in Rome. Why are they sitting in the frickin', the local parish? I think there's a mistake. And I think that was about all there was to really share. Oh, here's the W-9, right? So Kent County, Michigan, you call them and say, hey, I want a copy of your W-9. Email them. They'll be happy to send it to you. It's going to come in the name of the county of Kent. Well, then Kent County's usurping the position of the county of Kent. And the signature of U.S. person is supposed to be the signature of the U.S. person up here. County of Kent, which should be its seal. And then maybe by with somebody's name. But that isn't what they did. So Brooke Smith, right, she committed perjury because this isn't hers. That's not her EIN number, and she didn't have her Social Security number on here, so it isn't her. Sorry, Brooke. I forgive you. Okay. I'm believing that that is really all I wanted to talk about for today, was that right there, and the fact that the main fact, going back to the beginning, is that if you go and you were to look at the Journal of the House of Representatives for the very first session after an election year, there should be in there listed all the people that took an oath, subscribed and put it in, but it isn't in there. So, right, because doing a roll call by somebody's last name doesn't mean they took an oath. How do I know that man moved his lips? I don't. They have to subscribe the damn thing, and they have to give it to the clerk, and then one copy needs to be put into the journal, and it's not there. So they're not holding the office. Now, the Senate, it is in there, but what the Senate has to do is they have to provide, I'm going to go find that so that I can get it right, because they have to provide something too. So hang on a second. And then we'll be done. Okay, 2 U.S.C. 1A, election to be certified by governor. It shall be the duty of the executive of the state for which the senator has been chosen to certify his election under the seal of the state to the President of the Senate of the United States. Not the President of America, the President of the Senate of the United States. So that's very interesting. That's another thing I'm going to look into, is every state has 2 senators. They were supposed to have provided a copy of their certificate of election, or supposed to have been provided, to the President of the Senate of the United States. And so the Secretary of the Senate should have a copy of it. And if they don't have it, well, then they're not elected properly either, and we're going to have an empty Capitol here shortly. If one person would just do their job. So if anybody knows an MP, provost marshal, somebody in Homeland Security, somebody that will frickin' do their job and follow the Constitution, there's at least 430 odd people running around claiming to be congressmen that if they didn't file their oath, and there is no evidence so far to say that they did, then they're not holding the office. And you need to kick their ass out. And we need to reset. So, all right, that's what I had to say. And you all have a great day. We'll see ya.